Right from the jump, you can feel the setup. Two defendants, both heading toward jury trials, both convinced they've cracked some hidden legal code. But instead of strategy, what we're about to witness is confusion wrapped in confidence. The narrator tees it up perfectly. One defendant plans to stay silent, yet can't resist speaking. That contradiction alone tells you how this is going to unfold. Less like a defense, more like a slow-motion collapse.
I have Ms. Rael appearing in person today in the courtroom. I have Mr. Barnett at the District Attorney's Office. We sent this matter over for a pretrial readiness conference. We're set for trial on March 12th at 8 a.m. Ms. Rael, I see that you're still representing yourself in this matter. Is that correct?
I would like to invoke my right to remain silent.
All right. Mr. Barnett, anything from the state we need to take care of?
No, Your Honor.
All right. We're set for jury trial on March 12th. And we'll come back one more time for a pretrial readiness conference. I did issue a case management order in this case on November the 3rd. Ms. Rael, you are required to comply with that case management order. I do want to ask you a couple of questions just to make sure you understand that you do have a right to represent yourself. I understand that you've typically just stated that you wanted to exercise your right to remain silent, but I want to go over this with you. You understand that the allegations that you're facing are up to a Class 1 traffic offense, which is up to 364 days in the county jail. That is the maximum penalty on that charge. How much education do you have, Ms. Rael?
I would like to invoke my right to remain silent.
All right. Do you understand that there are legal complexities in this case that ultimately, that even though you're representing yourself, that you're going to be required to, under the same standards, rules of evidence that the district attorney would be under? Do you understand that? Do you understand that,
I would like to invoke my right to remain silent.
Ms. Rael, this has nothing to do with your innocence or your guilt. I'm trying to determine whether or not you're capable of even representing yourself. I've been very, very patient with you. You haven't even stated your name. I'm not even quite sure that you are Ms. Rael. I called Ms. Rael to come up here and you stand up here, and so I'm basing on that an assumption, I guess, that I'm making. But I have to establish certain things to make sure that you understand what you're faced with here. You have a right to remain silent of anything that might implicate you in any sort of criminal activity, whether or not you've gone to schools that are making it. It's called an Arguello advisement, so we refer it to. It's to make sure that you understand that I know that you're competent to represent yourself. Do you want to represent yourself in this matter?
I am invoking my right to remain silent.
All right, I'm going to take that as a yes. You understand, obviously, you have a right to remain silent. Finding that you can represent yourself in this matter, we're going to go ahead and continue on with the jury trial. We'll set this for one more pretrial conference. Mr. Waldo Mr. Barnett.
The judge starts calmly, professionally, laying out the schedule and confirming representation. It's routine, structured, and predictable. Everything the courtroom depends on. But the moment the defendant invokes her right to remain silent, you can already sense tension brewing. Because in court, silence is strategic, not theatrical. And here, it feels less like a legal move and more like a shield for uncertainty.
Put me in a compromised situation. I do not speak Latin.
Okay.
I do not know the Latin language. Am I in your commercial jurisdiction?
Ms. Rael.
Or,
okay.
let me speak.
Okay, if you want to speak, yeah, go ahead.
Am I in your commercial jurisdiction? Are you going to give me an interpreter? I still do not understand. I don't know what's going on. My freedom is at stake. I have the right to counsel. My freedom's at stake. You charge me a fee. You separate common law to my freedom with commercial law, where you impose a fee on me.
All right, so Ms. Rael, I'm going to interrupt you. Ms. Rael.
It both ways.
Ms. Rael, I'm going to interrupt you now. So do you...
Which jurisdiction?
Ms. Rael, if you don't stop, I'll hold you in contempt and I'll put you in custody. Stop. You clearly understand the English language, and I'm speaking to you in English. Do you need an interpreter in another language? Because I'm not speaking in Latin. I'm speaking in the English language. You just stated to me that you have a right to counsel. Would you like an attorney appointed to represent you?
Can I finish speaking? Can I finish speaking?
What do you need to say, Ms. Real?
Okay, then I am invoking my right to remain silent. If I cannot speak, then I am invoking my right to remain silent.
Then what would you like to say?
I'm trying.
As the judge continues, the process remains straightforward, confirming trial dates, expectations, and compliance. But what stands out is how patient the judge is being, giving the defendant multiple chances to engage meaningfully. This isn't hostility. It's the system trying to ensure fairness. Yet, the defendant's refusal to respond properly starts to shift the tone from cooperative to strained.
Standing for the court, but I'll give you a couple of minutes to complete whatever it is you wanted to say, but we're not at trial at this point. I'm trying to just determine whether or not you understand what's going on. Would you understand the English language? It's very clear to me that is the case. And I'm not speaking to you in Latin, Ms. Real.
Am I in your commercial jurisdiction or am I under your common law jurisdiction of the Constitution? You compromise me in every single way when I come into the courtroom. You strip me of my right to bear arms by running me through a metal detector, already compromising my rights as an American. You force me into a room where you have sentries with body armor, guns, pepper spray, tasers. You sit me down in a chair and then you ask me if I understand? No, I do not understand. You violate me through and through, and then in the middle of the game, we get halfway through the hearing, you change it, and then you spark out some word in Latin, and I am sitting here confused as all heck, asking me if I understand. If I don't put up and tolerate with your actions, you will have your officer standing up against the wall, pull out his weapon to scare me and throw me in a dog cage. You are acting criminal, corrupt, and evil and demonic. I do not understand, and therefore you cannot form jurisdiction over me. You speak a foreign language that is regulated from Britain.
Okay,
in
Ms.
America,
Real, that's
in
enough.
America, you
Ms. Real,
speak English to me.
Ms. Real, that's enough. I've heard enough. Okay, so you obviously understand the English language. Okay, so you are under the jurisdiction of the court. That is the jurisdiction that you are under. You are in the Conejos County Court. I am the Conejos County judge, and I do have jurisdiction over you.
Can I finish?
No, you cannot. I'm not going to continue to listen to this. This is what we're going to do. You are set for trial on March 12th. You will show up here for trial on March 12th. If you don't show up, I will issue a bench warrant for your arrest. We are going to have a trial March 12th. You have the right to counsel. If you would like to apply for counsel, you clearly understand that because you just told me that you have a right to an attorney. There is an application right there on that table. You can fill out that application and you can provide that to the public defender's office. They can enter an appearance for you free of charge if you qualify. That is your right to an attorney. If you don't want to apply, and that's absolutely your choice, you get to elect that. But we are going to trial on March the 12th, and you will be here for trial on March the 12th, and we will put it to a jury, the allegations against you. That is what we're going to do.
Okay, well then, can I get that in writing?
You have it on the record. We'll be here March 12th for a trial.
What time is that?
Start at 8 a.m.
All righty.
We won't need to come back for another pretrial conference, Mr. Brown.
Now the judge tries to establish something crucial: competency. Representing yourself isn't just a right, it's a responsibility. The court needs to know you understand what you're doing. But instead of engaging, the defendant repeats the same line. It's like watching someone ignore the rules of a game while still insisting they can win it.
This is Michaela Mayberry. I'll take entries. I'll start first, Ms. Becker, with you.
Amanda Becker for the people.
All right, and I note this matter was set at 1 p.m. for a motions hearing. It's currently 1:03. Ms. Mayberry does not appear. I'm going to give her to 1:05, and then we're going to move forward. Ms. Becker, can you remind the court, has there been any failures to appear in this case?
Your Honor, I was just looking at that. We did have ones early on, and she did have to be extradited from Texas. But she has been since on bond and in Colorado and appearing for the last several. Our last FTAs weren't since August of 2023. She also has a revocation matter in Adams County. She did appear at their last hearing in October of 2025. And then I just checked Vine Link and she does not appear to be in custody.
Okay.
Give her to like 1:15.
Okay. All right, we'll wait 10 minutes. All right, we're back on the record in 23 CR 884. I'll note for the record that it is now 1:20. This matter was set at 1 p.m. Ms. Mayberry does not appear.
Given that there was the older FTA, the age of this case, and that we have had to extradite her from Texas, I do think the $20,000 cash surety is appropriate. She also has somewhat of criminal history for VPOs primarily, and some other trespass to dwellings. So also a history of not complying with court orders, which is also why I'd asked for the $20,000 cash surety.
All right, what the court's going to do, I'm going to find that Ms. Mayberry has failed to appear. I'm going to revoke her bond. Court's going to issue a warrant. Court will set a new bond in the amount of $20,000 cash or surety that is based on Ms. Mayberry's prior history of failing to appear, as well as her criminal history and the severity of the underlying charges in this case. We'll maintain our trial dates, and I think we need to see when Ms. Mayberry is picked up. And
Here's where the disconnect becomes obvious. The judge carefully explains legal standards, emphasizing that self-representation doesn't mean relaxed rules, but the defendant treats every question as if it's a trap rather than a safeguard. Ironically, the court is trying to protect her rights, while she resists the very process designed to do so.
Thursday at 1 p.m. 1 p.m. Ms. Mayberry, you need to be there right at 1 p.m. Court's going to call at 1, and we're going to move forward. Court will quash the warrant that was previously issued. Ms. Becker, is there anything else? Any discovery updates?
Thank you. Your Honor, I did want to alert the court. I did provide Ms. Mayberry a copy of all of the discovery in this case today via a USB. I also had her sign a document noting that she's received that discovery. It does have all the both media and the PDFs in this case. I did also get a good email address for her today. So if there are any trial preps that create potentially new discovery that we usually create around trial preps, that would be the only thing we would be emailing her new. Otherwise, all the discovery is in. And then lastly, the people did just want to make a brief Lafleur record.
Yeah, please go ahead.
Thank you. Ms. Mayberry is charged with a Class 3 felony for burglary that has the possibility of 4 to 24 years in the Department of Corrections. It is, we do consider her enhanced due to a case being open at the time, which is Adams 20 CR 4209. That's what makes the enhanced range 4 to 24 years. She is still probation eligible, even if convicted at trial. The offer on this case was to a Class 4 felony for burglary in the second degree and a Class 5 felony for palpo, which is possession of a weapon by a previous offender. That is also the enhanced range with the possibility of 2 to 12 years and is still probation eligible.
Okay. Ms. Mayberry, do you have any questions about that?
Just the verbiage.
Okay. What part of the verbiage?
All of the verbiage of it.
So let's, I guess, break it down then. Ms. Becker, the offer is to...
It would be for a slightly lesser felony. It's still called a burglary in the second degree, but it's one step down. That's why you go from a 4 to 24 range to a 2 to 24. And then a Class 5 felony for palpo, which we would, if she was sentenced on both the F4 and the F5 palpo, we would ask for a sentence together in that range of 2 to 12 years.
Okay. And the palpo is possession of a weapon by a previous offender. So if you proceed to trial, the potential sentencing range that the court can impose is 4 to 24 years. The offer is a plea to a charge which would set the sentencing range from 2 to 12 years. Okay? Because we're proceeding on this case, the district attorney is making this record because there's not going to be any further offers. We're going to proceed to trial on this case. Do you understand that?
Yes, Your Honor.
Okay.
The people don't object to a bifurcation. I do think that makes sense to do the palpo and the VPO after the other two charges. And for defense 8 for the motion in limine, the people would not be...
Frustration begins to surface. The judge points out something basic. He doesn't even have confirmation of her identity. That's not a technicality. It's foundational. Yet the defendant continues repeating her scripted line. At this point, it's no longer about silence, it's about avoidance. And avoidance doesn't hold up in a courtroom.
Miss Mayberry is present. Miss Mayberry, you were late today. What happened?
I'm
You
sorry?
you were late today.
5 minutes?
Yes. I told you on Tuesday that I wasn't going to have you late for today's hearing. You need to be on time.
I have to take public transportation, Your Honor.
I told you about this hearing on Tuesday. You could have made arrangements to be here on time.
And yes, I did.
And
Got
you were
here
late.
As soon as I could, Your Honor.
Okay. What I'm going to say, Miss Mayberry, we're set for trial. If you are going to be late for any of those trial dates, I'm not going to keep the jury waiting for you. I will remand you into custody for the trial if we need to do that to make sure that you are here on time. Okay? We have people waiting. You need to be on time. We're going to go forward. Ms. Becker, we're going forward on the defense's motion to suppress show up identification. Are the people prepared to proceed?
Yes, Your Honor.
All right. The people.
The judge makes a practical decision. Interpret her silence as agreement to proceed. It's a turning point. When you don't engage, the system doesn't stop. It moves forward without you. And that's exactly what's happening here. The process isn't waiting for her to catch up.
Yes, it was a general call for service.
And are you aware that there was a 911 call that kind of preceded that call out?
Yes, it was a 911 call for a burglary in progress is what it was coded as.
And did you review the 911 call that was involved in this case?
Yes,
And when you listened to that phone call, did you recognize the voice of the caller on that call?
yes.
Who was it?
Felisa, the homeowner that I eventually contacted in this case.
Your Honor, the people would move to admit People's Exhibit 1, which is the 911 call in this case.
Ms. Mayberry, do you have any objection to People's 1?
No, Your Honor.
All right. People's 1 will be admitted.
No, what is the address of your emergency? Stay on the line, okay? This is Jeff. I'm with the transfer. It's gonna be 9665 West. I'm just gonna spell it. David, Adam, Nora, Zebra, Ida, George, Place. What's going on there? I walked in on a robbery at my house. Okay. They walked into your house and there was a female inside your house? Yes, they broke into our gun safe. They take any of the guns? I think so. I ran out of the house. I'm sorry. That's okay. Take a deep breath for me. Did you see them leave your house? Yes, she went through the front door. And you said that they did take the guns? I think so. I ran out. I didn't look to see, but she was in the gun safe. And I don't think there's anything left. Was it just one person? I saw just one person, yes. Just one. The female, can you tell me, was she white, black, Asian, Hispanic? Asian or Hispanic. And she had on all white clothing? Yes. Okay, and there was a white hoodie, you said? Yeah, some white pants. Okay, it's okay. When you saw her, did she have any weapons in her hand? No, she was holding my son's Xbox. Okay. But she was in my office in the gun safe.
On that call, did the victim indicate if the person was a male or a female?
Female.
And how did she describe her race?
Hispanic or Asian is what she described it as.
And how did she describe what the person was wearing on their face?
An M95 mask.
Okay. And did she describe what the person was wearing?
All white.
Thank you. And that was with a hood?
Yes.
Okay. And did she also say that she was thin-billed?
Thin-billed, yes.
Thank you. So after that point, where did you transport the victim to?
Hogback Hill Park, which is where my officers had detained the person that matched the description given.
How far was that from the house that was burglarized?
It's a few blocks, not very far at all. A drive less than 2 minutes.
Would it have been within walking distance?
Yes.
And where was, when you kind of got on scene for that show up, can you describe where was the suspect?
Sure. The suspect had been taken out of the patrol car, was standing next to the patrol car with my two officers that were on scene, and approximately 20 feet from where my vehicle eventually stopped for the show up to occur.
Were the two officers next to the suspect in uniform?
Yes.
And you said it was a patrol car. Was it a marked patrol car?
Yes, marked unit.
Was the suspect detained in handcuffs?
Yes.
And When were you wearing body-worn camera on that day?
I was.
And was it working correctly?
Yes.
Have you reviewed that in anticipation of today?
Yes.
Your Honor, the people would move to admit People's Exhibit 2 and just do a 1-minute clip from officers' body-worn camera of that day.
Any objection to 2?
No. No, Your Honor.
Miss Mayberry, I'm not sure you're appreciating.
Then comes the sudden shift. She starts talking. And not just talking, but launching into confusion about language, claiming she doesn't understand Latin. The irony is immediate. No one is speaking Latin. This moment exposes the gap between perception and reality, where misunderstanding is mistaken for injustice.
You can go ahead.
So I just have to ask you these questions. Do you recognize the person you viewed?
Yes,
Okay. If so, from where do you recognize them?
my office in my house.
Okay. And are you confident, somewhat confident, or not confident at all?
Confident.
Okay.
And then and how did she indicate that she knew her from?
From in her home, in her office.
Thank you. There was somebody else on that clip. Who was in the car with you all?
Her husband, she had requested that her husband go with us. She was greatly distressed and had requested that he ride with us while she did the show up.
Prior to the victim indicating that she recognized the victim, did her husband say anything like, "That's her," or did he identify her before the female victim said anything?
No, he said you can't recognize her from the clothes or can't recognize them from the clothes. And that's as we were driving past. It's like, is that them? And she said, I don't. And then he's like, you can't recognize from the clothes. And she said that she needed to turn around. So there was no recognition from him prior to.
Did he ever make statements about his knowledge about the suspect?
Yes.
When was that?
We were going through property that had been located and on the suspect at the time of being detained. And we found a Jeep car key. And the husband then said, oh, I think I know who this person is. And it was all in relation to having found a Jeep car key.
And how did he say he recognized the suspect?
He said that he had interviewed her for an in-home massage therapist position and had elected not to hire her.
Did he indicate how much earlier that interview occurred before this burglary?
I believe it was in January.
Okay, so like in
3 months.
So like in mid-January 2023?
Yes.
Her argument escalates quickly. Questions about jurisdiction, demands for interpretation, claims of confusion. But instead of clarity, it's a flood of disjointed ideas. The judge, trying to maintain control, has to step in, because at some point, the courtroom isn't a debate stage. It's a structured process that requires focus.